Hi, I'm Kevin Crowley. I'm an attorney with Hupp and Crowley, and I'm here today to talk to you about shoplifting and organized retail theft. Now, normally I would talk about these separately, but I think that these two charges are so closely related that it's actually better to talk about them together. So I'm going to give you an example first. A client of mine that I previously represented to demonstrate this. My client, she had a lot of things going on at the time that this incident occurred. She was involved in litigation in a foreign country. Her brother had recently suffered a traumatic brain injury. She was taking care of him. And she had a lot of other stuff on her mind at this time. But she went to Target. She always takes reusable bags with her. During this trip to Target, she put some items into her reusable bags. She went through the checkout, paid for the other items, and was stopped at the door. When she first told me this, I thought, okay, sounds like a normal shoplifting case. But then she told me that it was charged as a felony. This is surprising, just because most shoplifting cases are not felonies, but hers was, and it was charged as organized retail theft, not shoplifting. So what we were able to do in that case was show the prosecutor that her offense was no different than a misdemeanor shoplifting offense. We presented all of the mitigating factors that were going on in her life, and she was able to get a diversion program. That worked out well for her. So why was she charged with organized retail theft when ultimately the offense was very much like a misdemeanor shoplifting? And the answer to that is in the statute. So I'm just going to look at the statute here and read that to you. And person commits shoplifting if, while in an establishment in which merchandise is displayed for sale, the person knowingly obtains such goods of another with the intent to deprive that person of such goods by removing any of the goods from the immediate display or from any other place within the establishment without paying the purchase price. So I think we all kind of get that. That's shoplifting. If you take a CD off the rack at Target and walk out the door with it, you've committed shoplifting. One thing to note in that statute is that the person has to knowingly obtain the goods in order for that person to be guilty of shoplifting. How does the state prove that somebody did it knowingly? Well, the statute guides us on that. And it's presumed that the person has the culpable mental state knowingly if the person knowingly conceals on himself or another person merchandise, or uses an artifice, instrument, container, device, or other article to facilitate the shoplifting. Remember that. I'm going to come back to that in a minute. I want to tell you what the organized retail theft statute says. That statute says a person commits organized retail theft if the person, acting alone or in conjunction with another person, 1, removes merchandise from a retail establishment without paying the purchase price, with the intent to resell or trade the items. And 2, uses an artifice, instrument, container, device, or other article to facilitate the removal of merchandise from a retail establishment without paying the purchase price. Now, you'll note that that language is the exact same language from the shoplifting statute. So, if a person uses an artifice, an instrument, a container, device, or other article to help commit the shoplifting. So if somebody puts a shirt into a bag, if somebody puts a CD into a box that they have with them, that is 1, proof that the person committed shoplifting knowingly, but 2, a basis for charging the shoplift as a felony, because that fits the organized retail theft statute. Unfortunately, what you end up getting charged with depends a lot on how the officer is feeling that day. because the officer can write a citation for shoplifting as a misdemeanor and send you on your way, Or the officer could book you into 4th Avenue Jail and charge you with a felony. So it is extremely important that if you're charged with organized retail theft or shoplifting, that you have competent representation on your side. The client I mentioned earlier, she was having a hard time in her life due to a lot of other circumstances. We were able to present that to show that what she did was no different than a misdemeanor shoplift, and we were able to get her into the diversion program. Now, if you're charged with a misdemeanor shoplifting offense, many jurisdictions will allow diversion for a first-time offender. So if you've been charged with organized retail theft or shoplifting, please call us here at Lane, Hupp and Crowley. We can help you with this by presenting the prosecutor with mitigation, by presenting novel arguments regarding the actual statutes, and help you try and get out of this. So please give us a call. We look forward to helping you.